Good afternoon, everyone. This is Attorney Steven Sabra. You're listening to Law Talk on 1480 WSAR. We do this show every Tuesday from 1 to 2 p.m. It's your opportunity to call in with any law-related questions. Our call-in number 508-673-1480.
And the executor of a will, is he responsible for credit card debt if the deceased has no assets?
No is the answer to that. No, the executor is not responsible. Now, just for our listeners, the little exception to the rule, and that is that certainly if the executor signs to be responsible or signs some kind of paper or begins to pay the debt when there's no assets, that could be a problem. Also, if, for example, there are assets in an estate and the executor disperses all the money before a year from date of death is up, then the executor can be personally liable for that particular debt. But in a case where there's no assets in the estate, then, and by assets I mean probate assets, money, property in the deceased name alone, then the executor is certainly not responsible. And sometimes what happens is that there might be, let's say there's a bank account of $15,000 in the deceased name alone, and there's creditors, there's credit cards and other bills. Well, what's entitled to priority is funeral expenses and expenses of administration, including attorney's fees. So if you have $15,000 only, and you have a $7,500 bill for the funeral and the rest of it that goes with it, as well as attorney's fees and filing fees and that type of thing, that estate's going to be insolvent, and there's going to be no money left for creditors. So, so that can happen. That happens as well, but definitely the executor is not personally responsible to pay bills if there's no assets in the estate.
Okay, thank you.
Okay, thanks for the call. My name is Attorney Steven Sabra. You've been listening to Law Talk on 1480 WSAR.